Okay. Okay. Thank you so much. The Honorable Madam Justice Maureen Rajnath Lee, Judge, Caribbean Court of Justice. The Honorable Madam Justice Roxanne George Wilshire, Justice of Appeal and Chief Justice Acting of Guyana. The Honorable Mr. Justice Francis Cummerbadge, Judge of the Supreme Court of Belize. Ms. Abebe Asefa, Head of Cooperation for the Eastern Caribbean, Global Affairs Canada. Ms. Michelle Gibson, Senior Development Officer, High Commission of Canada to Barbados. Ms. Diana Shaw, Gender-Based Violence Consultant. Distinguished judges, Juris Project team, ladies and gentlemen. A special good morning to each and every one of you, and thank you so much for your patience. I wish to thank everyone for joining us this morning as we launch the revised model guidelines for sexual offenses cases in the Caribbean region. The Juris Project is pleased to have played an integral role in the development of the model guidelines, first drafted and launched in 2017, and now in 2022, developing a much improved tool for all actors within the justice chain, for survivors of sexual violence and those that advocate for the rights and justice of those that have experienced a violation of their rights. Since its inception in 2014, the Juris Project, with support from the Government of Canada, has been working closely with judiciaries in the Caribbean to support their own efforts to improve gender sensitivity, gender responsiveness, court administration, and the ability of the courts and the judiciaries to resolve cases efficiently and fairly, particularly cases involving sexual abuse and exploitation. Our aim is to strengthen judicial officers and court staff with the skills and competencies necessary to deliver justice in a fair, predictable, efficient, and timely manner. The ultimate goal of the Juris Project is to develop a regional judicial system that is more responsive to the needs of women, men, youth, and the poor. This particular intervention represents one of the several that we have supported in collaboration with our regional partners in Barbados, Belize, the Eastern Caribbean, Guyana, Jamaica, and in Antigua and Barbuda. I invite you to visit our website and Facebook pages to learn in more detail about the various initiatives being undertaken by the Juris Project. In May 2015, the project established an advisory committee consisting of representatives from the Caribbean Court of Justice, judiciaries of Trinidad and Tobago, Jamaica, and Barbados, UN Women, UNICEF, CARICOM Secretariat, and UWI in Jamaica to review the treatment of sexual offense cases in the Caribbean region. The following major gaps in the justice chain for sexual offenses were identified. Poor investigative and evidence gathering procedures by the police, inordinate delays in the completion of cases, undervaluing of sexual offense cases in relation to the public interest, so that limited resources are instead reserved for other serious crimes such as murder, lack of data collection to form the basis of monitoring and accountability of the court's performance and quality in responding to sexual offense cases, insufficient interconnectedness between the courts and the other key agencies required to facilitate proper investigation of the crimes and provide care of the victims through the process. The survivors' refusal to pursue cases for fear of re-victimization by the very process of seeking justice. In 2017, the Juris Project, in collaboration with regional partners, launched the model guidelines for sexual offense cases in the Caribbean region. The model guidelines serve to provide internationally accepted best practices for the management of sexual offense cases and offer a rights-based approach to the treatment of complainants and vulnerable witnesses, including children involved in sexual assault cases. Ultimately, the guidelines will increase public confidence in the justice system as it relates to the handling of sexual assault cases, improve responses to survivors that will enable their full participation in the justice system, increase offender accountability, and reduce secondary victimization. Ensure a trained and skilled cadre of cross-sectional professionals, including judges, court personnel, police and attorneys, to efficiently respond to sexual assault cases, survivors and witnesses, and ensure speedy adjudication of cases and reduction of case backlogs over time. In the subsequent 5 years since the launch of the model guidelines, the project has also worked closely with the Antigua and Barbuda High Court and the Eastern Caribbean Supreme Court, ECSC, to ensure the implementation of the guidelines via a specialized court dedicated to adjudicating sexual offenses cases. The court is known as the Sexual Offenses Model Court, or SOMC. We're also pleased by the efforts taken by Guyana to implement the guidelines through the support of regional partners. Guyana has since established 3 specialized courts. We applaud all the hard work in this area that is happening on the ground in Antigua and Barbuda and Guyana. The project recognized this year, which is our final year, as a great opportunity to relook at the guidelines with the aim of strengthening them in keeping with new and emerging regional and international best practices and responses to sexual violence. Subsequently, consultant Ms. Diana Shaw joined the juris team and engaged with stakeholders throughout the region in a review and revision process. I'd like to take this opportunity to say a special thanks also to President Saunders, Justice Rajnath Lee, Justice Smith, Justice Moore, Chief Justice Roxanne George, the heads of judiciary and court administrators for their support in the review process. Additional thanks are extended to survivors and civil society organizations whose input remain extremely valuable. It serves as a perfect reminder of the important partnerships and collaborations needed in the region to respond to sexual and gender-based violence. The Juris Project recognizes that without the support of you, our valuable stakeholders within the local jurisdictions where we work, none of our objectives will be achieved. We depend on you to ensure that all initiatives we undertake are sustained long after the project ends. We look forward to your ongoing efforts to improve and enhance the judicial systems in the Caribbean region to the benefit of all men, women, boys, and girls. Thank you so much.
Thank you for those remarks, Gloria. I think they serve as an excellent reminder of the progress that we've made in the coming years and a call to action to continue the hard work. I'll now like to invite Ms. Asifa from Global Affairs Canada to present her remarks this morning.
Thank you. Thank you very much. And please let me know if there are issues with the sound. Thank you very much, and good morning. Good morning, everyone. I'm here with my colleague, Michelle Gibson, and it's a pleasure for both of us to be here and to bring you greetings on behalf of the Government of Canada. I'm new to the region, as I've only moved to Barbados 2 months ago, but even in this short period of time, I've been able to learn about all the positive work that's being done to strengthen the justice sector, and I'm very pleased to see the support that Canada has been able to provide through key regional stakeholders like all of you who are here this morning. The Judicial Reform and Institutional Strengthening Projects that we all know as the Juris Project is one of the 2 regional initiatives that the Government of Canada is supporting in order to strengthen justice in the Caribbean. The Juris Project, with a budget of 20 Canadian million, is delivered through the Caribbean Court of Justice and aims to modernize and strengthen Caribbean judicial system by re-engineering processes and building the capacity of judicial officers to deliver fair, timely, predictable, transparent, and of course, effective justice. As part of the effort to focus on troubling delays in the court system, it was a committee comprised of regional stakeholders that, from the onset of the project, determined the need for a focus on the treatment of sexual offense cases. As highlighted by the director of the JURIST project, I believe it was about 5 years ago in 2017 that Canada, with collaborating agencies including UN Women, UNICEF, the University of the West Indies, the CARICOM Secretariat, and national judiciaries, alongside others in the justice system, participated in the development of and the first series of launches of the model guidelines for sexual offenses cases in the Caribbean. Over the years, we're very pleased to see that the guidelines have become an important tool, providing guidance to actors along the justice chain in their response to sexual and gender-based violence across the Caribbean region. Since launching the guidelines, the Government of Canada is also pleased to have further supported its implementation in the Eastern Caribbean Supreme Court with the establishment of the Sexual Offences Model Court located in Antigua and Barbuda. We thank the Chief Justice, the Honorable Dame Janice Pereira, for the foresight of the Eastern Caribbean Judiciary in taking such an innovative step. This model court, as you all know, is intended to ensure speedy adjudication of cases and reduction of case backlogs over time, improved response to survivors that will enable their full participation in the justice system, increase offender accountability, and reduce secondary victimization, the use of a skilled cadre of cross-sectional professionals, including judges, doctors, court personnel, police, and attorneys, trained to efficiently respond to sexual assault cases. Increased coordination among justice sector stakeholders. As a result of this work to establish the model court, Canada was also pleased to support the government of Antigua and Barbuda to update its Sexual Offense Act in 2019, while contributing to work on a model sex offender register bill for the region. This support was provided through the other regional projects supported by the Government of Canada that we all know as the Impact Justice Project, the Improved Access to Justice in the Caribbean project. I was also pleased to hear of the recently hosted exchange of knowledge led by jurists between national judiciaries and regional legal actors to discuss the use of these guidelines by those who have applied them in their work over the years. Canada applauds the work of Guyana Judiciary for taking the guideline firmly in hand and establishing multiple specialized courts across Guyana. I wish to thank the Honorable Madame Justice Yonette Cumming-Edwards, Chancellor Acting of Guyana, and the Honorable Roxanne George Wilshire, Chief Justice Acting, along with all the members of the Guyana Judiciary for their work. I also wish to thank the Caribbean Court of Justice for its leadership through the Honorable Justice Saunders, President of the Court, and the work of the Honorable Madame Justice Maureen Rajnaud-Lee with the support of the project gender specialist, Ms. Salima Bacchus-Hinds. Sexual violence remains a pervasive issue within the region, and resolving this violence requires the deep commitment, collaboration, and innovation across all sectors within and external to the judicial system to ensure success. We need everyone on board to effect the change urgently required. The Government of Canada therefore remains committed to supporting and strengthening the judicial and legal system and promoting reforms that eliminate all forms of gender discrimination and violence. This is, of course, in line with our Feminist International Assistance Policy, which has placed the empowerment of women and girls at the core of all our development initiatives. As I'm sure you will agree, the revision of the guidelines for sexual offenses should never be static, and we hope that this exercise motivates the region to ensure that the guidelines stay dynamic and provide for further interest in ensuring accessible and empowering courtrooms for survivors of sexual violence. Following on the Antigua Model Court and Guyana Specialized Court, we're keen to see the use of the model guidelines expanded throughout the region so that more women, men, children may benefit. The success of such courts should provide for improved access to justice and improve public confidence in the judicial system's ability to address sexual violence in a timely and transparent manner. Today is an opportunity to recognize your accomplishments so far and also your intention to learn from practice, adapt further, strengthen, and catapult the fight for gender justice. I wish you continued success. Thank you.
Thank you. Thank you for those wonderful words, Mrs. Difa. I'm really looking forward to see, the developments across the region as we move forward with the model guidelines and other responses that strengthen our approach to sexual and gender-based violence and efforts to reduce and eliminate the violence in the long run. So thank you so much for those words. I would just now like to invite Justice Rajnath Lee, who will give us a bit of background information on the model guidelines. Justice Rajnath Lee has been an advocate and champion for these guidelines from its inception. And I'm personally really grateful for her guidance for the past 2 years, her guidance and her support, particularly with the revisions. She's been very active, and Justice Rajnath Lee, really thank you, because I think, what we're able to achieve, it's really dependent on your efforts and the efforts of everyone that's really placed a lot of input and given us time to ensure that we have a strengthened document. Judge, I'll share the presentation and then we can go through.
Thank you so much, Salima, and good morning to all distinguished ladies and gentlemen. And allow me, please, to adopt the protocols which have been established. I wish to express sincere appreciation to the Juris Project team, and in particular to Mrs. Gloria Richards-Johnson, its Executive Director, and to Ms. Salima Bacchus-Hines, its Regional Project Coordinator and Gender Specialist, for this invitation to make some brief remarks, give you some background on the model guidelines. I wish to thank these two ladies publicly for the key roles they have played in bringing this important initiative to fruition. As you undoubtedly have heard before, an important component of the Juris Project is the Sexual Offences Project. And Salima, you can move to the second slide. The Sexual Offences Project has as its objective improving the capacity of regional courts to deliver gender-responsive and customer-focused court services in such a way that complainants in sexual offense cases are not further traumatized when they interact with the justice system. You may have heard me say on previous occasions that the two key initiatives of the Sexual Offense Projects are: 1, the development of model guidelines for treating with sexual offense cases within the criminal justice system in the Caribbean, and 2, the establishment of a sexual offenses model court in a Caribbean jurisdiction to test the effectiveness of the model guidelines. In order to monitor the implementation of the Sexual Offences Initiative in 2015, the project established an advisory committee. I was privileged to chair that committee. As you have heard this morning, the committee comprised representatives from the Caribbean Court of Justice, judiciaries of Barbados, Jamaica, and Trinidad and Tobago, representatives of UN Women, UNICEF, the CARICOM Secretariat, and the University of the West Indies Mona campus. In 2015, as the advisory committee began its work, a baseline study was commissioned through UN Women. The study identified the several major gaps and challenges which were discussed a little earlier by the project director, Mrs. Richards-Johnson. I wish to highlight one of them because I think for judicial officers, for persons involved in this project, in this initiative, what is key is the question of delay in this particular type of case. When the baseline study came back, one of the things that we were told was the inordinate delays within the criminal justice system, that this was having a very negative impact, especially on the survivors of sexual violence. We observed over the years, and in particular with this project, that delay is the enemy of justice. In November 2018, the Judiciary of Trinidad and Tobago launched its Gender Equality Protocol for judicial officers. In the chapter which deals with sexual offenses, the protocol makes the point that delay is particularly egregious in the prosecution of sexual offenses. In response, the Juris Project undertook the task of developing guidelines for sexual offense cases in the Caribbean region as part of a comprehensive and multi-sectoral approach to improving the management of sexual offense cases and the treatment of witnesses and survivors of sexual offenses. On the screen, you will see, and I think we always think it's important, because Ms. Diana Shaw, a consultant who we will hear of later, was there at the time, that there were some over 200 persons consulted for the development of these guidelines. We consulted with survivors of sexual offenses, women, men, indigenous persons in Belize and Guyana, persons who had experienced sexual assault and interacted with law enforcement and the courts as children and as adults, some as children and as adults in the same case, non-governmental agencies who represented survivors, judicial officers, court administrators, court staff, defense counsel, prosecutors, police officers, medical practitioners. These consultations provided a comprehensive assessment of how sexual offense cases were being adjudicated in the region, and critical gaps and challenges were documented. Priority subject areas for the model guidelines were also identified. The model guidelines were launched, as you heard, in 2017 at the Biennial Conference of the Caribbean Association of Judicial Officers, CAJO, which was held in Curacao that year. Towards the end of 2017 and into 2018, Juris hosted several regional and national launches, together with sensitization workshops to familiarize judicial officers, lawyers, police officers, prosecutors, advocacy groups, and the like across the Caribbean on the contents of the guidelines. The model guidelines have incorporated several internationally accepted best practices. They offer a rights-based approach to the conduct of sexual offense cases. As I have repeatedly said over the years, the guidelines contain 3 key components which are critical to the improvement of the justice system in this area. The first one, and it's on the screen, proactive case management by the courts to eradicate delay and to reduce trauma. 2, the early identification of vulnerable witnesses. And 3, the use of special measures to ensure that the best evidence is given by vulnerable witnesses. I am pleased that the revised guidelines have not only built on these critical components, but have also expanded on several important areas of adjudication, such as judge-alone trials and sentencing. I am sure that we will hear more about these from Miss Diana Shaw, attorney at law and gender-based violence consultant, who must be commended for her professionalism and the excellent work done to produce these revised guidelines. By the end of 2017, pleasant winds of change were blowing across the Caribbean. Inspired by the Juris Project, the Judiciary of Guyana, in November 2017, established its first sexual offences court at the High Court in Georgetown. I am proud to say that this was the first sexual offenses court established in the Caribbean. In January 2019, the Sexual Offences Model Court was launched in St. John's, Antigua. 2 more sexual offences courts have been established in Guyana, and it is our hope that other jurisdictions in the Caribbean will recognize the value of these specialized courts and will follow suit. As I close, let me say that I am not one for including in my remarks the comments of other persons. But as I prepare these remarks, I came across the following comments made by 2 eminent judges, and I just could not resist. So permit me, please. As long ago as 1998, Justice Desiree Bernard, now retired, the esteemed former Chancellor and Chief Justice of Guyana, and the first woman judge of the Caribbean Court of Justice, closed her remarks on the International Day Against Violence Against Women by pointing out, and I quote, "The time to act has come. We are all involved. We shall all be consumed. We may have in place all of the laws to protect women, men and children from violence, whether physical or sexual. But unless we are sensitized to the need for action, the laws will be meaningless. We can no longer stand silently by and remain uninvolved. We need to break the silence and exhibit zero tolerance for acts of violence. We must aim to promote in our society a culture of non-violence and respect for human rights. May I say, and I end quote, may I say that Justice Bernard's comments are as relevant today as they were in 1998. And in addition, I wish to repeat the words of my brother judge, Justice Jacob Witt, judge of the CCJ. Justice Witt made brief remarks at the launch of the Sexual Offences Model Court in St. John's, Antigua on the 21st of January, 2019. Speaking on behalf of the president of the court, Justice Witt concluded his remarks by making this appeal, and I quote, "The main issue here is, however, not the new case management techniques or the new rules that will govern that new case management. The main challenge is, with all due respect, how to achieve a fundamental change in judicial attitude and that of the lawyers required properly to guide the new approach. It requires, in fact, a new and fresh look at the role of the criminal trial judge, a role that must be more proactive. If not, and I know that I'm in hot waters here, inquisitorial, in the sense of judge-driven. This has nothing to do with judges descended into the arena and often and superficially used expression. It goes directly to the core of the trial judge's task and constitutional duty to ensure that trials are fair, efficient, and held within a reasonable time." End quote. I say yes to my sister and yes to my brother. The time to act is now, and we who are involved in the administration of justice are ideally positioned to make a difference. Salima, again, and Gloria, I thank you for this information, for this invitation, and thanks so much, ladies and gentlemen, for your kind attention.
Thank you so much for those words, Judge. I think it's an excellent call to action to, again, take that work forward. And if anyone has any comments they would like to leave in the chat, or any questions based on what Justice Rashnath Lee has presented, please do put this in the chat and we can address them towards the end of the program. At this moment, I would like to hand this over to the Honorable Madam Justice Roxanne George Wiltshire, Justice of Appeal and Chief Justice acting in Guyana. to just give us some insights in how the model guidelines have been implemented in her jurisdiction and the impact those guidelines have had on court users.
Thank you, Ms. Backus-Hines. And like Justice Reginald Lee, I crave indulgence of all to adopt the protocol established. Distinguished attendees, a pleasant good morning to everyone. On behalf of the Honorable Chancellor, Madam Justice Yonet Cummings Edwards, and colleague judicial officers in Guyana, I bring you greetings and express appreciation to the Juris Project for inviting us to participate in this launch of the revised model guidelines for sexual offenses in the Caribbean region. Thank you for affording me this opportunity to make brief remarks. The enactment of the Sexual Offences Act in Guyana in 2010, as amended in 2013, which provided for the establishment of a sexual offences court, fostered an increased focus on addressing this form of gender-based violence in a more holistic way. It was in November 2017 that the original model guidelines for sexual offenses in the Caribbean region was launched in Guyana in conjunction with the establishment of the first sexual offenses court here and in the region in the county of Demerara in 2017. Thereafter, 2 other sexual offenses courts were established in the counties of Berbice and Essequibo in 2019. We are grateful to UNICEF, the Canadian and British governments, and the Juris Project for their tangible support in establishing these courts, thereby assisting the judiciary to be more responsive to the concerns raised in our society about the conduct of sexual offenses cases. Judicial officers from Guyana have been privileged to play an integral role in the development of the model guidelines. And here we are 5 years later, benefiting from our experiences and collaboration across the seas of the Caribbean by these revised guidelines. The letter of invitation to the launch of the original guidelines said, and I quote, "The guidelines are intended to provide internationally accepted best practices for the management of sexual offense cases and offer a rights-based approach to the treatment of complainants and vulnerable witnesses, including children involved in sexual assault cases. Additionally, the guidelines will ensure that complainants are not re-victimized as they seek redress from the justice system," end quote. In Guyana, the Sexual Offences Act, along with the guidelines, have definitely resulted in the implementation of best practices for the better management and conduct of cases, ensuring respect for the human rights of victims and accused, and gender sensitivity. No doubt engendered by the paper committal system, cases are dealt with more expeditiously, and in the High Court, oftentimes 2 cases are tried per week. The guidelines permit the more uniform adjudication of sexual offenses cases and have allowed judicial officers to be more comfortable conducting court in a less formal, non-traditional manner, while ensuring that the decorum and rules of court are not compromised. A very victim-centered approach has been adopted because we appreciate that a supportive environment for victims or survivors is necessary to ensure that their interactions with the justice system are less traumatic. Robes are not worn by judges and counsel. Audiovisual links to special measures rooms are routinely utilized, and accommodations are made to allow victim advocates and other support persons to be present in court. In some instances, intermediaries have been used to assist victims or survivors to testify. In these regards, governmental social services and non-governmental partners, including child advocacy centers, play a critical role. The system of state-assigned lawyers has been extended to sexual offenses cases so that survivors are not cross-examined by accused. The length, type, and tone of cross-examination are monitored and managed by judicial officers. Courts accommodate survivors and witnesses with breaks and have even facilitated counseling. All this so that they can give their best evidence. Summings up are prepared in adherence to the guidelines and the Act. And as regards sentencing, victim impact statements are a feature of this aspect of trials. In all these regards, judicial officers are committed to dealing with these cases justly while ensuring that where the verdict so allows, there is accountability and that impunity would not be tolerated. It would appear that the legislation and the guidelines have resulted in greater confidence in the justice system, for there has been an exponential increase in the numbers of cases listed for trial in the High Court. Of a total of 511 cases countrywide, 241 or 47% are for sexual offenses. Clearly, sexual violence continues to be a scourge in our society. Going forward, it will require not only the continued commitment to the application of the guidelines, the legislation, and all the measures to support survivors of sexual violence, but it will require an increase in the number of trained judicial officers to adjudicate in these cases. The training of a larger pool of defense lawyers in the guidelines so as to provide representation for accused has also been suggested. Overall, the view is that the guidelines have made a positive impact on access to justice for victims or survivors while guaranteeing accused a fair trial. I must conclude my remarks by expressing profound gratitude to the Juris Project, which has played such a meaningful role in the development of the justice sector in Guyana and the region. Juris Project, with its expert, professional, dynamic, and engaging team members, has been a major partner of the judiciary of Guyana over the years, funding a number of projects and activities that have enhanced access to justice, not only in the urban areas, but importantly also in the rural and hinterland communities. The project has indeed lived up to its mandate to engender a justice system that is more responsive to the needs of women, men, youth, business, and the poor. As I looked back at the 2018 Charter, outlining the collaboration between the Juris Project and the Guyana Judiciary, I found that two of its goals were to provide a strengthened, customer-focused, and gender-responsive court, and enhance judicial service delivery. The revised sexual offenses model guidelines are tangible evidence of one of the many ways in which the Juris Project has delivered so that our judiciaries can deliver. I thank all who have contributed to the revision of the model guidelines, more especially Ms. Diana Shaw. We look forward to the continued collaboration with Antigua and Barbuda and other regional judiciaries as more sexual offenses courts are established, and as we continue the work of updating and revising the guidelines. Best wishes for the future, more especially to all the team members of the Juris Project. Thank you very much.
Thank you, Chief Justice. Really appreciate those words. And, you know, it's really great to hear that consolidation of the information regarding or the impact that the model guidelines has had on Guyana in terms of improving access to justice, reducing that backlog. I can say as a Guyanese citizen and an advocate in these areas that we have seen the noticeable difference in terms of how cases are adjudicated. Years ago, you might hear a story of someone waiting 10, 15 years for a matter to be resolved. But we quickly are seeing, that is becoming a thing of the past. And the cases are being addressed in a much swifter manner. But that percentage that you shared, it was shocking for me that almost half the cases that we're seeing are sexual offenses cases. And it just goes to show that we are responsive, but there's still, there's still a lot more work that needs to be done in terms of shifting the culture around sexual violence in our society. And of course, the judiciary has an integral role in facilitating or encouraging that shift, that cultural shift that we desperately need. So thank you again, Chief Justice. Really appreciate your input. I now hand you over to our consultant, attorney at law, sexual and gender-based violence expert, Ms. Diana Shaw, who has been for, I think, the last 3 months, has been leading a lot of the stakeholder engagements. Most of you would have met with her in the past couple of months, and she has led the revision of these model guidelines. So today, she just briefly take us through some of the revisions that have been made recently in keeping with best practices and in keeping with the experiences that have occurred over the last 5 years, and building those experiences into strengthening the model guidelines. Diana?
Thank you so much, Salima. And I too would also ask for your indulgence in adopting the protocols that have already been established and welcoming all of our distinguished attendees and participants. It has truly been a joy and a pleasure to have been involved in this work. This is my key area of focus. Most of the work that I do professionally as well as in my community-based life is around gender-based violence. And 5 years ago, when I was chosen to be the consultant to work on the original model guidelines, I felt that I was participating in something that was to become a life work, that it would be something that would have significance even beyond me. And I am thankful that I have the opportunity to look back at that process through this revision and to see the progress that has been made and to see the impact of that, but also to see the areas for additional strengthening and work that would now be done and to the best practices that have evolved since then. So this has truly been a joy. And I wish to express my sincere thanks to the Juris Project team for entrusting me with this task, and to all of the judiciaries, the court staff, the NGO stakeholders, the government, ministers, CEOs, and departments that participated across the Caribbean to give input to make this document what it is, and going forward, what it will be. So what I'm going to be sharing is just a really short snapshot of what the revised model guidelines is and what they hope to achieve. So the original intent is still there to ensure that this document is responsive. We have coined the term that this is a living document. So there is an expectation that there will be further review processes in the future as changes occur in the adjudication of sexual offenses in the Caribbean region that need to be documented, and as additional guidance is needed by our different jurisdictions. One of the things that we did in the revision was to develop a greater link between the other processes that support the adjudication of sexual offenses and the actual access to justice. And it is important for that because survivors don't just interact with the court, and the court is not the first place that they interact with. In fact, much of the interaction is actually outside the court, and it begins much earlier with the law enforcement portion of the reporting. So we have included in the revised model guidelines a graphic that shows the justice chain and this interconnectedness that is required, because while the model guidelines is focused on strengthening adjudication, the extent to which adjudication will achieve its ends is also dependent on those other stakeholders having strong systems and producing and bringing to the court the strongest cases. So that is to show that, and you will also hear later on as I talk about the guidelines now giving additional guidance on how to establish sexual offense courts, that this is not only important for the survivors, but also for the efficient working of the court, that the court also has to have this strong multi-sectorial coordination mechanisms with the other actors and stakeholders who are a part of the justice chain to ensure that as the court is making advances and changes, that they're also responding to that, and that they're making the necessary adjustments, and those other parts are also being strengthened. So this justice chain graphic is to give the users of the model guidelines a quick snapshot on the different key stakeholders that are also involved, and to remind them that this is a part of the process, not the entirety of the process. In addition, there is a graphic that gives that shows the key stakeholders, who those stakeholders are, the police, who are responsible for reporting, but importantly, and there is a move throughout the Caribbean to ensure that the point of reporting is also being grounded in good practice around survivor care and protection, so that healthcare and psychosocial support care providers are also responding at that earliest level with support for survivors, and that there's a victim-centered approach that is involved even in the police reporting response. So that is demonstrated in this graphic. It is also one of the thematic areas of the justice, of the model guidelines, that the justice chain and the responsiveness of adjudication is also dependent on proper survivor care and protection. We also show the prosecutors, attorneys, and the judicial officers and court administrators who are part of this chain. So what does the revised model guidelines offer, and what does it contain? So it strengthens the purpose that was stated in the original guidelines to use those internationally accepted best practice for the management of sexual offense cases. And I would also say that it adds to that by also documenting regional best practice, not just best practice that is outside of our jurisdictions, but the best practices that are now emerging, because now we have specialized courts that are showing that with effective, proactive judicial management, with showing that with effective use of special measures, they are showing that with the strong coordination with those support services, that we can provide adequate survivor care and protection without derogating from the rights of defendants, and be able to capture best evidence that gives the public a greater sense of confidence in the judicial system, in the adjudication of sexual offenses, and promote efficient administration of justice. So we have international best practices, and we have now much more regional best practices that are also highlighted in this revision. Of course, we have maintained the rights-based approach in the treatment of both complainants and defendants, the identification from the earliest stages, even before the court process, going back to the law enforcement response of vulnerable witnesses and the needs that they will have to facilitate them properly participating in that process. In addition, the outcomes from the original model guidelines are further strengthened in this revised guidelines. The increased public confidence, as I said before, we now have courts in Antigua and in Guyana, and we heard just now the remarks of Chief Justice Roxanne George Wilshire that there is a demonstrable change in the public's attitude towards the reception of the courts. And this is something that we can use to encourage those other jurisdictions that are thinking about establishing special offense courts. And this is also one of the outcomes of the project, the improved response to survivors, ensuring a trained and skilled cadre, a cross-section of professionals to respond to sexual assault cases, survivors, and witnesses. One of the main aims of doing this document and presenting it is so that both court administrators and judicial officers will have a tool that can be used for further professional development, continued sensitization, and training. As an accompaniment to this document, I have developed a sensitization tool that can also be used by court officers, by judicial officers, with other judicial officers who are added to the team to orientate them on the use of the sexual offense model guidelines and also on the other practices of the court. The hope is that this will result in speedy adjudication and the reduction of the backlog of cases. And as was highlighted, the issue of delay is particularly prevalent in sexual offense cases. Unfortunately, in many of our jurisdictions, cases involving murder and other firearm offenses are given priority. And those cases, if they take up the time of the court, the sexual offense cases usually get delayed. And so those jurisdictions that are moving towards more specialized responses, part of the justification for that is to clear up this backlog that they have been experiencing in sexual offense cases. The guiding principles for the document, the rights-based approach, looks at the protection of both the rights of the complainants and the defendants, and this is balanced throughout the document. So one of the things that the document does, it talks about the proactive use of case management, both at the magisterial level and also at the high court level, to ensure that any issues that defendants may have or concerns are irritated and dealt with and addressed. And this continues throughout the trial. It also enshrines the principle that services are to be provided in a judgmental way, that specialized training facilitates professionalism in the delivery of services and the treatment of any personal bias. Services must not re-victimize the complainant. Vulnerable complainants and witnesses are to receive specialized support services, and that the response to service delivery must have recognition to the traumatic and disruptive nature of sexual assaults. Therefore, a multidisciplinary approach is going to be required. And of course, the protection of privacy and confidentiality is key. In terms of the content of the model guidelines, the guidelines provide guidance to judicial officers, court administrators on the pretrial process in summary jurisdiction offense cases, as well as in the high court. It talks about the need for effective case management, and this was mentioned earlier. Justice Rajnath Lee, in her comments, indicated the increased emphasis on this, and the guidelines certainly underscore that and provide some much needed additional guidance in this revision to the magistrates and to the high court judges on how this can be effected. So the guidelines provide for the magistrate court to consider using those first hearings as case management hearings. It talks about even where your jurisdiction does not have a specific legislation that set timelines as part of the magistrate's oversight responsibility is to ensure that documents, that things that are required to be done, there's a set date that is set within a reasonable time to do that. But the guidelines also highlight the best practices of countries like Belize that have now established timelines. There are regulations that set timelines. Countries like Trinidad in their criminal procedure rules have set timelines for the entirety of proceedings. We're seeing practice directions from judicial officers, from the chief justices of the different regions, also setting those timelines and giving magistrates a much more increased oversight responsibility. And this is part of one of the underlying themes that runs throughout the document, that the magistrate must drive the process. The magistrate must direct the process, not the magistrate must give the proper directions, set the proper procedures in place for things to flow very well. The guidelines also has some revisions as it relates to bail proceedings in sexual offense courts. All of our jurisdictions allow for bail proceedings in sexual offenses. The guidelines give some additional guidance on considerations that the judicial officers should contemplate in bail hearings. The guidelines give additional guidance on disclosure. One of the things that have come out recently, especially in Belize, Belize has now passed the Protection of Witnesses Act, which allows now for magistrates to have the power to issue orders that will protect the identity of certain vulnerable complainants upon applications being made to the magistrate. And the guidelines reflect that those best practices are highlighted. It's something for other jurisdictions who are looking at strengthening witness protection and the care of survivors, especially who are particularly vulnerable, to also look at if they require that kind of guidance. The guidelines also talks about the preliminary inquiries, the processes in the high court for case management. Usually in our jurisdiction, there's much more guidance from criminal procedure rules for the processes in the high court. So the guidelines reflect the direction in which those criminal procedure rules are going in the Caribbean to ensure that everyone has access to what is happening if they are contemplating changes in their jurisdiction. In terms of the guidelines as well, so the first part deals with the pretrial process. The next portion of the guidelines deals with the trial process itself. And there are some revisions that have been included in terms of some of the adaptations that have been made in the various jurisdictions of the Caribbean, particularly in response to COVID. As you are all aware and know, during COVID and face-to-face hearings were not possible, all of our jurisdictions adopted methodologies to allow for virtual hearings. And in all of the Caribbean countries, this is now becoming a feature of the judicial process. This will remain even beyond COVID. And this is something that the guidelines also reflect in this revision process. The guidance to the judicial officers and consideration for those virtual hearings, the kinds of practice directions that need to be passed, the management of the trial process in that virtual space to ensure the proper protection of the rights of the survivor as well as the rights of the defendant. That is now reflected in the revision. In addition, the revision talks about the new adaptations that are coming, such as substituting previously recorded statement that was done through a video recording of the witness or the virtual complainant during the law enforcement reporting space, for that now to be allowed in evidence as the examination in chief, where the evidence rules and practices of the particular jurisdiction allow for that to be done. In addition, the guidelines underscore the continued need for survivor care of particularly vulnerable complainants. There's a focus on persons with disabilities, persons from indigenous communities, and the specialized needs that they have that must be considered in addition to the general guidance that is given for proper survivor care and protection. Persons with disabilities, there are issues connected to physical access, but also issues that may be connected to how they are able to give evidence in court. And the guidelines underscore the need to look at the use of intermediaries, the need to provide additional support, to have support persons for them, and especially in using virtual hearings and technologies, they need to ensure that the technology is going to be effectively used by them and able to support them, giving the best evidence possible. Those are things that are highlighted. In indigenous communities, they need to consider vulnerability, as it will particularly affect persons who are coming from communities where they may be isolated, where they may have to come out of the community to participate in a judicial process, the implications of that and how the court should assess that and the kind of support that they will need. And those kinds of things are also provided for in the guideline. In addition, during the trial process, there has been new learning that is coming from case law, particularly from the reasoning of cases in the Caribbean Court of Justice that now impacts summing up, and it particularly impacts sentencing. So a substantial portion of the revision of the guidelines during the trial process covers the changes that have occurred in the summing up process and the new guidance that is coming from the Caribbean Court of Justice as it relates to sentencing. We have shared the latest case law that is coming from the Caribbean Court of Justice, what that means for the jurisdictions in the Caribbean. And we have also given in this revision live links, active links in the document to all of those resources that are mentioned, so that judicial officers, court administrators will be able to click on those names, will be able to click on the links in the footnotes to go directly to the source material to see it in its entirety, and to also include that in any training or advocacy or public education activity that they may be involved in. In addition to that, the guidelines in the trial process portion looks at the importance of the court recognizing that survivor care and protection continues beyond the court process, so that the court has a responsibility to consider any ancillary orders that need to be made at the time of sentencing, to continue any kind of protection mechanism that was established during the trial process that will be needed after the trial process. The guidelines also talk about the importance of looking at child offenders, where we, in our consultations throughout the region, many of the stakeholders shared about the increase of child offenders in sexual offense cases and the need to have some legal reform to properly address that. There is some reform that is already happening, and the guidelines highlight that and give those links to those examples. But the guidelines also provide some general guidance and oversight to the judicial officers on how to deal with issues of non-custodial sentencing for juvenile offenders, the kinds of orders that can be made, guidance on the sexual offenses registry, and then some guidance on data collection for the court, which takes us in to the final portion of the guidelines. The guidelines provide guidance to the entirety of the justice chain on how to establish a sexual offenses court, a specialized court, if that is something that a jurisdiction is contemplating. There are specific guidelines that have come out from the knowledge exchange process between Antigua and Guyana and the collection of the best practice from both of those jurisdictions to ensure that you can learn from what has been done and build on that learning. So the guidelines provide the guidance on that to ensure that that can be done. This snapshot of the guidelines is also presented as the executive summary of the revised guidelines itself. And we also discussed during the process some procedures for making sure that the guidelines become more user-friendly. So you will be able to access not just hard copies of the document, but there will be e-versions of the document with those active links already enabled in the document that all the persons who are using it will be able to access all of the additional resources. In addition, the Juris Project has committed to put on its knowledge management system those source documents, as well as the other resources. The original model guidelines had those booklets for the police, the medical personnel, as well as the Survivors' Rights Charter. Those resources will still be available, as well as the additional resources that have been developed by Juris since then. So that's the model guidelines in a snapshot. We again want to thank all of the persons who participated and want to encourage all of the judicial officers. You will be getting some instructions from Salima and when you will receive those documents, but go through it, use it, and be very interactive with it. Thank you all.
Thank you, Diana. Is there, any questions or any comments that anyone would like to make at this time as we wrap up? Gloria, is there anything you wanted to,
I saw Chief Justice.
Yes.
Chief Justice, did you have a hand up just now?
Yes, yes, thank you.
Thank you.
No, it's just one comment. Excellent work, and to emphasize our commitment to continuing to use the guidelines across all the across the entire justice sector in Guyana. But just to emphasize that work clearly needs to be done to reduce sexual violence in our societies. I heard what Diana just mentioned at the end in terms of utilizing the guidelines in training and in sensitization. I don't know, Justice Rajnath Lee, you might want to provide some guidance, maybe a bit outside the remit of the courts, but the reduction, the move to reduce the numbers of cases would really impact the numbers of matters that come before the court or engage the attention of the courts, because as I mentioned, I think increased confidence in the justice sector has led to increased numbers of cases that are coming on for trial, both in the magistrates courts and in context of Jamaica, parish courts and the high courts. But we have a human resource deficit. And that's why, we need more trained judges. We need more judges just generally, at least in the context of Guyana. I don't know the stats for Antigua and Barbuda, but we definitely would need to have more trained judicial officers, and so that we can increase the pool of persons in the justice sector. I think human resource deficit in our societies is a critical area. How do we get the numbers of requisite skilled personnel, not only as judicial officers, but also to support the courts and the work that has to be done? So that's my comment. It's not to be negative, but just to be realistic. This is just a reality in our small jurisdictions. Thank you.
Okay, Salima, I think you'd asked if I had anything to say. I just wanted to once again congratulate everyone. And I wanted to indicate how fortunate we were to be able to engage Diana, once again, you know, when we spoke to Justice Rajnath Lee, because both Salim and I were not here when the guidelines were initially prepared, and Justice Rajnath Lee and the team, John and Allison, you know, told us about Diana and her excellent work. We were thinking, my goodness, 5 years ago, we're not too sure we'd be able to get her, but we were very, very fortunate. And she was available, willing to do it. And once again, Diana, I want to thank you so much for an outstanding job. You and the entire team of very busy judicial officers and others who have dedicated so much time for this to be a success. I also want to thank once again the Government of Canada, which has always been there, backing us, supporting us, engaging with us, finding out the needs of the region. And we really want to thank you all. I think this has been an excellent launch. And thank you so much for your participation. And I think that, you know, even as Juris closes out, you know, the Juris project has about, what, 5 months ago? I think we closed out in March 31st, 2023. But I think this was very important to us that we revise these guidelines so that once we hand over, you know, everything goes on through the CCJ, they don't have the responsibility of having to do this. But as we indicated, this is a live and evergreen set of guidelines that as we move forward, the judicial officers would make recommendations for change as we move forward. So thank you so very much, everyone who has participated in this very important initiative. And I think this has really been an excellent launch. Thank you so much.
Thank you, Gloria. I see 2 hands up. First, Nurse Wong from Antigua and Barbuda. Nurse Wong is Executive Director for Women Against Rape. And she has been an active partner on the ground in Antigua as we had helped establish a sexual offenses model court in that jurisdiction. Nurse Wong, please go ahead.
Thank you, Madam Moderator. Distinguished ladies, on behalf of my organization, Women Against Rape, we are very pleased that we have been afforded the opportunity to be a part of this process. Who sits at the table is a very, very important concept that we always need to bear in mind. And it is evident from this process that the role of NGO and civil society has been noticed and has been involved. I would like to thank also the Juris Project and everyone else who has been involved in this process from the beginning and throughout the revision of the model guidelines for sexual offenses case in the Caribbean region. My term as chair of the local multi-sector stakeholder committee comes to an end in December of this year. And I am quite sure that my colleagues in Antigua will be able to take up the challenge as we move forward. The startling statistics of 47% in Guyana is something for great concern. I am quite sure that if we were to investigate deeper into our own situation in Antigua, it may be the same or very near the same. Thank you all for being a part of this process, and let us all continue to work assiduously so that we can eliminate sexual violence cases and all forms of violence in our lovely Caribbean. Thank you very much.
Justice Rajnath Lee.
Yes, thank you, Salima. I won't be long now. Our thanks publicly to Nurse Wong. Nurse, I believe you were there from the very beginning when we met around the table. You know, a little uncomfortable, but we had to do what we had to do. And so I want to thank you publicly for all the work that you and your committee have put in Antigua to make so much of what we've done a success there. I wanted to say very briefly, Salima, if you would allow me, then not everyone may know that in addition to all these projects and all the wonderful work you all have done, I say that jurists, like the people in Galilee, you left the best for last, because you're doing a project with persons with disabilities. And I just thought that it would be such a wonderful idea, Salima, when you do that e-copy, that you can put the link to the best practices and the model guidelines that will be developed by a consultant with the persons with disabilities, improving access to justice for those persons. You can link it here, because as we discussed with that consultant, the intersectionality of vulnerabilities is so evident and important in these areas. So just a suggestion that you could link both of them. So the model guidelines are in your checklist and your access to justice guidelines for persons with disabilities. And so you link in both, and you link in everything, because you see so much of vulnerabilities in these areas. Thanks a lot.
Thank you, Judge. I just one final comment that I have from someone, Profile Executive Director. Hello, good day.
Hi, Joan Burke-Skeen, the Executive Director of the Belize Family Life Association. I want to join the others by congratulating the team on excellent work done. And like Ms. Wong said, we really appreciate the recognition of the contribution of this kind of work by civil society organizations. And I am glad that we looked at sexual violence and we added gender-based violence, because I'm hoping and I'm looking forward to what these guidelines can do also to support our regional response to gender-based violence, because very often with GBV comes sexual violence or sexual offenses. And many times women do, even if they're with their intimate partner, they do not recognize or accept that they are victims of sexual violence when they're in these kinds of relationships, where they're being raped by their partners, wives are being raped by their husbands, and they do not recognize this as a violation. So I really want to congratulate all who have been involved, and I'm looking forward to us going the other step in one, achieving what we want to do, reducing sexual violence in the Caribbean and making Caribbean the model region as we address these issues. So I want to say thank you all, and for affording me the opportunity to participate in this excellent launch. Thank you.
Thank you, everyone. So that's it for today. I'd like to just thank you once more for giving us a bit of your time on a Friday morning, and we really appreciate it. We appreciate the input that you've given up to us over the last couple of months to help in the development of this product. Just to let you know, our immediate next steps as it relates to the guidelines is final editing and production. We'll also be printing some copies so that we can distribute across the region. And the civil society partners in this room, while the guidelines really serve as a model for the adjudication of these cases, is also a very important tool for advocacy, as you all know, in terms of advocating for the rights of survivors, educating survivors on their rights and what to expect from the justice system. So I look forward to the next steps that we have moving forward in the further adoption and expansion of the model guidelines, and seeing even more improved access to justice for survivors, and ultimately, seeing less cases reaching the court, because we've reached a place where there are less sexual violence in our society. So again, thank you all, and I'll hand you to Diana, and then we'll close off. Diana, last words.
Thank you, Salima. Just to ask for you to take a picture of the participants, if we could get everybody to come onto their cameras, let us see those big smiles, and so that Salima can get a
Could you,
picture of all of us.
could you take off the share screen so we could get the
Yes.
gallery? Yes. Okay, so do we have to say cheese in this moment or
Yes.
doesn't? Okay, 1, 2. 1, 2. Okay, somebody. 1, 2. One more person. Okay, great. I see you, Miss Humphrey. 1, 2, 3. Got it. Thank you so much, everyone.
Thank you.
Thank you all.
Thank you.
Excellent.
Thank you.
Bye.
Bye,
Thank you.
everyone.
Bye,
Bye.
Bye.
Care.
Everyone, hi, Mish.
Thank you.
Bye.
Bye-bye.
Hello, Michelle. I didn't see you.
Bye.
It's in there. Bye.
Bye.
Bye-bye.